Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. On June 3, the new Canadian government tabled Bill C-2 in Parliament called An Act Respecting Certain Measures Relating to the Security of the Border Between Canada and the United States and Respecting Other Related Security Measures, but with a short title of the Strong Borders Act. As the name implies, it's mostly about border measures, customs stuff, fentanyl and immigration. But once again, following the footsteps of past Conservative and Liberal governments, it contains a Trojan horse that revives what has come to be known as lawful access. The bill contains a number of search, seizure, and surveillance measures that have nothing or little to do with the border or fentanyl. In the past, governments have tried to introduce similar measures under the guise of fighting terrorism, child abusers, and cyberbullies. Now it's apparently border security. I'm really getting tired of these sorts of bills, and for a brief moment I was hopeful that this new government would take a different route, but apparently not. I'm completely confident, though, that the lawful access provisions of this bill have been sitting in a drawer at the Department of Public Safety, desperately waiting for an opportunity to put it in a slightly relevant bill. I have some past episodes which are relevant to this discussion, which I'll put in the notes below in case they're of interest. In this episode, I'm going to focus on Part 14 of Bill C-2, which amends the criminal code in a bunch of ways. Part 15 creates a whole new law called the Supporting Authorized Access to Information Act, which I'll have to cover in another episode. There's more in there than I can fit into this episode, but I'll focus on what I think is a big deal in Part 14, having only read the bill a few times. Part 14 creates a new police order or information demand without judicial oversight or control to require service providers to hand over basic information about customers. It dramatically truncates the response time for production orders and unrealistically gives service providers only 5 days to challenge a production order. It amends the law to clarify that cops can just ask for information and service providers can just hand it over. It may also permit the cops to use illegally hacked and leaked data in their investigations. Part 14 also creates a new production order for subscriber information that police can get with only reasonable grounds to suspect that an offense has taken place, and is broader than most general production orders I've seen for what's called basic subscriber information. The bill creates a puzzling new warrant that allows a judge to authorize a peace officer or public officer to obtain tracking data or transmission data that relates to anything that is similar to a thing in relation to which data is authorized to be obtained under the warrant and that is unknown at the time the warrant is issued. So I guess if the cops get a warrant to track a certain thing and discover it's related to another thing that they can also use to track the person, they can get data from the second thing. Okay, maybe. Finally, Part 14 includes a weird judicial authorization to make a request for data from a foreign entity. Part 15 of the bill is deeply problematic as it creates a whole regulatory regime under which electronic services providers must follow regulations and secret orders so that police and the security services can tap into their systems. As I said, that'll be the subject of another episode. But yeah, already that's a lot. First up, let's look at the new information demands. This new section 487.0121 of the Criminal Code authorizes a peace officer or public officer without judicial authorization to make a demand of any person who provides services to the public. And that would require them to provide any of the following information on this list. Now, paragraphs A and B are clearly intended to deal with the situation where the police have a phone number and want to go to Rogers or Bell and ask, is this number serviced by you? And if so, where is the service provided? And also whether they have any customer records. They don't have to provide the records at that time. That gives the police enough information to refer the case to the local police where the customer is. For example, regularly the RCMP in Ottawa receive information from a foreign police agency that's just associated with an IP address. They've identified it as a Canadian IP address. They may know then that it's a Rogers IP address, but they don't know where the potential suspect is. Now Rogers will have to tell them, without a warrant or court order, yes, that's our customer and they live in Montreal. So it gets referred to the Montreal police. No directly identifying information is supposed to be shared at that point. Now, I don't have a big problem with this. I am concerned about the scope of paragraph E, however. it says they have to provide the name or identifier, if known, of any other person who provides services to the public and who provides or has provided services to that subscriber, client, account, or identifier, and any other information, if known, referred to in any of paragraphs B to D in relation to that other person and that subscriber, client, account, or identifier. So if the service provider knows that the customer in question gets services from anyone else, that also has to be disclosed. So if the Eastlink internet service customer has a Hotmail address on file, I think they might have to disclose that the person is also a Microsoft customer. Now, that could be more problematic if it's a company that supports OAuth logins, like using your Microsoft account to log into other services. This may require disclosing where those logins take place. The threshold for making such a demand is that they have reasonable grounds to suspect, a very, very low threshold. Reasonable grounds to suspect that A, an offense has been or will be committed under any act of Parliament, and B, the information demanded will assist with the investigation of the offense. The peace officer or public officer can also impose a non-disclosure order. The person receiving the order has only 5 days to seek to have the demand varied or revoked, and has to give notice to the peace officer or public officer of its intent to have the demand varied or revoked. Now, 5 days is not much in my view. And the threshold for varying or revoking a demand is if A, it is unreasonable in the circumstances to require the applicant to provide the information, or B, provision of the information would disclose information that is privileged or otherwise protected from disclosure by law. Now, demands like these seem unlikely to possibly disclose privileged information. The next significant thing in Part 14 of Bill C-2 is a production order for subscriber information. Unlike in previous lawful access attempts, this does require judicial authorization, but the threshold is very, very low. It's just above the police having a hunch or their spidey sense tingling. So we have a new section, 487.0142, which creates this new production order for subscriber information, again with a very low threshold that is simply reasonable grounds to suspect that an offense has been or will be committed under the Criminal Code or any other act of Parliament. And B, the subscriber information is in the person's possession or control and will assist in the investigation of the offense. So it reads 487.0142 sub 1. On ex parte application made by a peace officer or public officer, a justice or judge may order a person who provides services to the public to prepare and produce a document containing all the subscriber information that relates to any information, including transmission data, that is specified in the order and that is in their possession or control when they receive the order. Unlike a general production order, this order requires the production of all the subscriber information in the recipient's possession. The general production orders that I see on a regular basis name the specific data being sought. Now, these orders are for all subscriber information, which is broadly defined. It says in the bill, subscriber information means in relation to any client of a person who provides services to the public or any subscriber to the services of such a person, A, information that the subscriber or client provided to the person in order to receive the services, including their name, pseudonym, address, telephone number, and email address. B, identifiers assigned to the subscriber or client by the person, including account numbers. And C, information related to the services provided to the subscriber or client, including 1, the types of services provided, 2, the period during which the services were provided, and 3, information that identifies the devices, equipment, or things used by the subscriber or client in relation to the services. So let's look at A. It likely also includes billing information. If it's a paid service, like a cell phone, bank account, or credit card information would have been provided when the account was set up. I do not regularly see this in general production orders for subscriber information. And it's worth pointing out that these orders can be obtained to investigate any offense in any act of Parliament. So this is not limited to the Criminal Code or the Controlled Drugs and Substances Act or the Customs Act. This includes the National Parks Act. And I really must emphasize that reasonable grounds to suspect is a very low threshold. It is the lowest in our legal system, since our system doesn't recognize hunches or spidey senses. Now, I think this is in direct response to the Supreme Court of Canada's decision in R and Spencer, where the court said that police can't just ask for subscriber information, but it must be on the basis of exigent circumstances or in accord with a reasonable law. The government clearly thinks that this is a reasonable law that gets them there. Next up are applications for requests of transmission data or subscriber information from a foreign entity. The new section 487.0181 is a bit unusual, as it creates a power to authorize a request, not an order, directed at a foreign entity that provides telecommunications service to the public. The request is approved by a judge on an application by a peace officer or a public officer. 487.0181 sub 1. On ex parte application made by a peace officer or public officer, a justice or judge may authorize a peace officer or public officer to make a request to a foreign entity that provides telecommunication services to the public to prepare and produce a document containing transmission data or subscriber information that is in the foreign entity's possession or control when it receives the request. So the request is limited to transmission data or subscriber information. The threshold for issuing such a request is, again, reasonable grounds to suspect that an offense has been or will be committed under this Act or any other Act of Parliament, and the transmission data or the subscriber information is in the foreign entity's possession or control and will assist in the investigation of the offense. It's really weird. So the police go to a judge and get an authorization to make a non-compulsory request to a foreign entity. Essentially, all this does is make sure that the cop swears in front of a judge that they have reasonable grounds to suspect, and the judge concurs with this. But it's a request. It's not compulsory. Now, I expect this is strangely in response to the controversy surrounding the Brecknell case from British Columbia that questioned whether production orders can be issued naming entities physically outside of Canada. Now, this may also be intended to take account of agreements like a Cloud Act agreement, contemplating the inclusion of information that may be necessary under the laws of a foreign state. So it says in one of the subsections what can be in the form. The production request is to be in Form 5.00803 and may include any information that is required by the foreign entity, by the foreign state in which the foreign entity is located, or under an international agreement or arrangement to which Canada and the foreign states are parties. Now, while we haven't concluded a Cloud Act agreement, Cloud Act agreements negotiated with the United Kingdom and Australia require a certain level of criminality, so it wouldn't cover violations or offenses under the National Parks Act. But anyways, so I'm a little bit confused. Again, they're not court orders, but are issued like a court order. What the cop sends to the foreign service provider is the request and a copy of the authorization. And I think this will cause a lot of confusion. A large number of non-Canadian service providers will respond to a Canadian general production order, particularly where the investigation relates to a person that they can identify as being in Canada. For some such entities, their privacy policies say they'll only disclose information where required by law, and if they're following PIPEDA, our federal privacy law, with respect to Canadian customer data, as they should, required by law is one of the exceptions that allow a disclosure to the police. These requests don't trigger the required by law exception in our privacy policy. And some U.S. service providers require that the thresholds largely align with the American probable cause standard, and reasonable grounds to suspect does not meet that threshold. So cops may think that they just have to send a request, and the foreign service provider may say that's not sufficient. We want a production order. I note that these can be combined with an order of non-disclosure, which is binding at least under Canadian law. Now, whether it can really bind a foreign company, it's not clear. What's also puzzling is that officials from the government, during the technical briefing on the bill, said none of our Five Eyes partners, meaning the US, United Kingdom, Australia, and New Zealand, require an order for police to get subscriber information. And that's simply not my experience. Now on to what's called exigent circumstances. Clause 167 of the bill codifies what I understand to be the common law related to exigent circumstances. And just so we're on the same page, exigent circumstances exist where there is imminent threat to the public or public safety, or a risk of loss of destruction of evidence. So an emergency sort of situation. The code has generally permitted peace officers to search and seize in exigent circumstances if the conditions for obtaining a warrant exist, but exigent circumstances mean it would be impracticable to obtain the warrant. The provision at 47.11 of the code is being replaced to scope in powers that are available under certain production orders. The underlined portions are what have been added to the existing 47.11. But essentially this means that a peace officer, public officer, can make a demand that has the force of law without a court order where exigent circumstances make seeking the order impracticable. It's unclear to me whether a demand under paragraph B would have the same force and effect as a production order for the same data, and whether non-compliance could result in the same penalties of violating a production order. Also, Bill C-2 amends section 47.0193 to dramatically, and I think very problematically, truncate the window of time to commence a review to revoke or vary a production order issued under sections 47.014 to 018 of the Criminal Code. The new time frame is 5 days from the date of the order. It was previously prior to the deadline referred to in the order for the return of the materials, which is generally 30 days. And this is unworkable in my view. I regularly see production orders that were delivered to the service provider days after they were issued. I sometimes interact with cops who already have an order and want to know where to send it. After this amendment, the clock is ticking rather loudly. If a cop gets an order on a Thursday before a long weekend, delivers it on a Friday, it may not come to anyone's attention until Tuesday. And making a decision to challenge a production order isn't usually made by the person in corporate security who first reviews it. You'll have to go up a chain of command, and by the time the decision maker gets their eyes on it, the window will have closed. And they can't even make an application unless they get a hold of the cop to tell them that it will be challenged. In my experience, this will be completely unworkable for most service providers. For some time, section 47.0195 of the code has contained provisions that say a police officer can always ask for information that would otherwise be the subject of a production order, and to obtain that information where the person is not prohibited by law from disclosing it. Clause 164 of Bill C-2 amends this section to add subsections that clarify that this now includes data that could be subject to an information demand under the new section 47.0121. The section appears intended to provide immunity to a service provider who voluntarily provides information that would otherwise be subject to a production order. Now, Spencer still says that these disclosures have to be subject to a reasonable law or exigent circumstances. But anyways, so a cop goes to a bank, asks a bank or a telco to voluntarily provide customer data, and the bank or telco says, yeah, sorry, we can't because privacy laws prohibit it, and we've agreed with our customers that we'll only provide data where required by law. The cop can point to this section and say, well, so what? They can't successfully sue you, and you have no civil or criminal liability for providing the data. Now, personally, I would respond saying that our privacy laws are not about criminal or civil liability, so just come back with a warrant. And paragraph 4 says that cops can always use information that is available to the public. And I've heard some raise concerns that this would include data that's publicly leaked via hacking or other nefarious means. So the police can go trolling through the Ashley Madison leaks, I guess. I'll have to save the deeply problematic Supporting Authorized Access to Information Act for another episode, so stay tuned for that. Overall, I really hope the government gets a lot of shaming for putting this Trojan horse in the border bill. These expanded law enforcement powers are consequential, and they deserve to be appropriately discussed and debated. I think that's why the government actually decided to go this route, to avoid the huge outcry we've seen in the past related to prior lawful access attempts. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.